Mr. Ojeda, can you hear me at all? Christian Ojeda? This is Judge Chris Martin, 294th District Court, looking for Christian Ojeda with the Estes unit. If you can hear me, your phone is on mute. You'll need to unmute it. All right, the court's going to move forward. I don't know if Mr. Ojeda, if you can hear me or anybody from the Estes unit, but the phone is muted. And
Can you hear me now?
yes, I can hear you now. All right.
Yeah, okay.
All right. Is this Christian Ojeda?
Yes, sir.
Okay, Mr. Ojeda, I'm going to attempt to have you speak with one of my court administrators in a different setting. So I'm going to maybe send a message to you. If you get prompted with a voicemail message to join this room, I want you to join it and meet with my court staff, Ms. Patty Taberham, to discuss more options, okay?
Okay.
All right, I'm going to try to send you there, and give me just one moment.
Appreciate it.
Mr. Ojeda, were you given an option to join the breakout room?
No, they haven't given me no option. Just you right now, just telling me if I want to join.
All right. Hold what you got for just one moment, okay? Don't go anywhere. All right, Mr. Ojeda?
Mm-hmm.
All right, so this is Judge Chris Martin. I'm the district judge of the 294th District Court in Van Zandt County, and this is CR 17-211. Mr. Ojeda, you are currently incarcerated in the Estes Unit TDC, correct?
Yes, sir.
When are you expecting to be eligible for parole?
I already was already in September. I was eligible, and I got a year set off, just like a week ago.
A year set off, so you're not looking to be eligible until September of next year?
I'll be eligible for parole like in October of 2021.
And what's your current charge that you're on?
The charge that I'm at right now is assault with a deadly weapon.
Okay. And in our county, you are charged with a state jail felony offense of possession of a controlled substance less than 1 gram. Mr. Ojeda, do you have any funds to hire an attorney to represent you in this matter?
No, I don't.
Okay. All right. Is there a way that my staff member can contact you at TDC so that she can have you complete some paperwork for a court appointed attorney?
So the only thing y'all could do is just contact them, because that's how I got this court hearing. The you know what I'm saying? They told me that I had a court hearing, so I had to come. So it's like I don't have that many options. You know what I'm saying? Like I don't. It's like if I'm not gonna run somewhere, I'm already locked up. So yeah.
Do you
I don't know how that works.
Mr. Ojeda, listen. Do you have phone privileges?
I do, but I gotta, y'all gotta have to, like, I have to have the number approved in my line. You know what I'm saying? Like, so I just can't call any random number. It has to be the people that are in my line. They have to be on my system. If not, I can't just call nobody. You know what I'm saying?
Okay. Do you have? Is there any member of TDC staff that I can speak with?
Yes, there's one right here. If you want to talk to him right now.
Yes, please.
Yes, sir.
Yes, this is Judge Chris Martin with Van Zandt County. With whom am I speaking?
This is Frederick Copeland, Law Library Officer.
Law Library Officer. And
Yes,
sir, can you tell me what would be a good contact number for a member of my staff to contact your unit so we can make arrangements to have a telephone conversation between my criminal coordinator and Mr. Ojeda so that we can get him court-appointed counsel and some paperwork filled out?
Okay, the number here is 972-366-3334. My extension is 176. It'd be just as easy to email me the information, and that way, pardon me, I can make sure that he has the warden's permission, and we can set up the phone call.
Okay, excellent. Can you give me your email?
Yes, sir. It's Frederick, FREDERICK Copeland, COPELAND at MTC Trains, and that's TRAINS.com.
What was the first three letters again?
Of the name of the company, MTC.
MTC, okay. MTCtrains.com.
Yes, sir.
Okay, all right. Thank you. Okay, if you'll put Mr. Ojeda back on, then I'll have everything I need.
Okay, thank you, sir.
Thank you, sir.
Hello.
Mr. Ojeda?
Mm-hmm.
Okay, so a member of my staff will make contact with your unit and get some information to you regarding your request for court-appointed counsel. Once we get that paperwork filled out, then we'll be able to set up either a Zoom call or a telephone call regarding your appointment of an attorney, and then the attorney can start working on your case and try to hopefully get you some kind of resolution soon. Okay?
Yeah, because I was about to say, I was like, because if it's a state jail charge, like, could like time serve for it or whatever?
That's what your attorney in the state will have to work out.
Okay.
Okay, we're going to be in touch with you to get the paperwork we need, and once we get that, then we'll have an attorney get a hold of you, and the attorney can work on your behalf here, and y'all can try to reach some kind of disposition. Okay.
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 So is that it?
That's it. That's it for now, and we'll send that information down there, and we'll be able to communicate here soon. Okay.
All right. Thank you.
Hey, you're welcome. Have a great day. Tell the staff I appreciate their help.
All right. Bye.
Thank you. All right, Mr. Wyatt, are you ready?
Yes, sir, I am.
All right. Is this Mr. Rice?
Yes, sir, it is. We're here on the motion to adjudicate. The subject of the motion to adjudicate is a now newly indicted felony. We have not been set on that yet, Judge. I think if we just reset it for the 15th, I think we can kind of take care of everything. We should kind of be knowing what we're going to do by then, December 15th.
All right, it's his new charge. I don't see his new charge in the system. You said he's recently indicted in this county or another county?
In this county, I believe it's CR 20, maybe 306.
Yeah, there's no CR 2306 with his name on CR 20. Yeah, I've got no cases found. When I search him by name, I also don't show any new charges. Is this like a?
It was just indicted, Your Honor. Like, we got the indictment list last week.
Okay. All right, then the court will reset Mr. Rice then for a hearing on his motion to adjudicate on December 15th. And I may set the new charge if it appears in my system for arraignment on that same day.
Yes, sir.
All right, Mr. Rice, we'll see you on the 15th.
Sure.
Do we have any other inmates ready?
Your Honor, I got one other matter. Cody Pickett.
Is he there with you?
No, sir. He's in Tarrant County.
Oh, okay. He was set for plea today, is that correct?
We had set him up. We were hoping we might be able to get a plea set up. I've talked with Mr. Cox about this. I think he kind of wants me to contact Mr. Pickett's Tarrant County attorney and get a straight up kind of where they are on this again. Because my understanding was the last time I talked with his lawyer was that they were waiting to do the state and the defense were going to agree to do a full sort of psychological workup in preparation possibly of an open plea. I have not got any update on that yet. I received some correspondence from Mr. Pickett. Actually, I got it late, I believe Tuesday afternoon. And I believe from having looked at that and given his past history, I need to call his lawyer again and tell her what I'm seeing, what I'm getting and make her aware of it. I don't know what her position is at this time. He completed a competency restoration that was done by Tarrant County. That was some time ago. He's been awaiting trial in Tarrant County since he got found to be competent. I've made Mr. Cox aware of some of my concerns on this. I kind of feel like, at least on our end, he's charged with a much more serious crime in Tarrant County than he is here, as he's awaiting trial on an aggravated assault with a deadly weapon there.
Okay, well, let's do this. Let's just set it for Tarrant County custody status on December 15th.
Yes, sir.
We'll just check back every 30 days and see if we have any movement. And bailiff, who's our next inmate?
Your Honor, we've got Mr. Merleader with Bryce Lynn Jackson. Bruce. Sorry, Mr. Jackson.
CR 2170, State versus Bruce Jackson. Set for docket call, Mr. Merleader.
Yes, Your Honor. We have a plea for Mr. Jackson. Mr. Cox has the plea papers.
I'm ready when the court's ready, Your Honor.
Okay, I'll need the terms.
Yes, sir. We're going to reduce this to a Class A assault causes bodily injury. Mr. Jackson is going to be sentenced to 180 days in the Van Zandt County Jail, with credit for 136 days served, a fine of $250. We're going to ask the court to consider under 1245 DA code DA 2020-0501 with $270 in court costs and $765 in reimbursement fees.
You said it was 180 days with 136 credit,
Yes, sir.
and it's a straight up assault bodily injury, Class A, not family violence.
Correct.
All right, Mr. Jackson, if you will, I need you to raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So you got it.
Yes, Your Honor.
All right, put your hand down. Make sure you speak up as loud as you can. I know sometimes the mask makes that difficult, but just so that my court reporter who's here with me in the courtroom can take down everything you say. Understand?
Yes, Your Honor.
You're going to have to speak up a lot louder than that because I can barely understand.
Yes, Your Honor.
Excellent. That's much better. All right. You are Bruce Lynn Jackson, correct?
Yes.
And Mr. Jackson, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Smith County Behavioral Health Center diagnosed me with psychosis.
And are you currently on any type of medication for that? No? Do you feel like that you're able to understand and perceive rationally the proceedings here today?
Yes.
Are you having any difficulty with that disorder?
No.
No? Okay. In this case, you are represented by your attorney, Mr. Shrobness Merleader. Are you pleased with his representation of you?
Yes.
Do you feel like you've had sufficient time to talk with him about your case and have all of your legal questions answered?
Yes.
Is there anything about the plea that you've signed that you do not understand?
No.
Mr. Jackson, you were charged by indictment with the third-degree felony offense of injury to a child, elderly, or disabled individual with bodily injury. The plea agreement before the court is for you to plead to a lesser charge of Class A misdemeanor, assault bodily injury, with the sentence being recommended at 180 days confinement in the county jail, with you receiving 136 days credit, $250 fine, $270 court cost, $765 reimbursement fee to Van Zandt County, and having case number DA 2020-0501 being dismissed. Is that your understanding of the plea agreement?
Yes.
Yours as well, Mr. Merleader?
Yes, Your Honor.
All right, Mr. Jackson, to that Class A misdemeanor, reduced charge of assault causes bodily injury, how do you plead?
Guilty.
Are you pleading guilty because you are guilty of that offense?
Yes.
And has anyone threatened you, forced you, or otherwise pressured you to plead guilty?
No.
All right, the court will accept Mr. Jackson's plea of guilt. Mr. Merleader, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence. The court will take judicial notice of Mr. Jackson's judicial confession. Anything further from the state?
No, Your Honor, rest and close.
From the defense,
Nothing else, Judge. Thank you.
Mr. Cox, if you could just give me a brief summation.
Yes, sir, Your Honor. Mr. Jackson went to the Taco Casa up at the Duke's Travel Plaza at 64 and I-20. He went in without a shirt or shoes on. He was told to leave. He didn't like being told to leave. He became aggressive and combative, and a fight ensued where he shoved a 67-year-old employee of Duke's.
Any objection to that summation?
No objection, Judge.
I think Mr. Jackson got whacked over the head, did he not?
He did.
Did you receive any injuries from that, Mr. Jackson?
Having heart problems and my eyes messed up now.
All right, then based on the evidence before the court will find that there is sufficient evidence to convict Mr. Jackson of this offense. Court will follow the recommendation of the state and will assess punishment in accordance with the plea agreement. Mr. Jackson, you're hereby convicted of the Class A misdemeanor offense of assault causes bodily injury. Court assesses your sentence at 180 days confinement in the county jail. Court will issue you credit in the amount of 136 days for time that you have spent in jail on this cause. Court assesses a $250 fine, $270 court cost, orders you to reimburse Van Zandt County $765, and the court dismisses DA 2020-501 under Section 1245. Mr. Jackson, upon being released from the Van Zandt County Sheriff's Office, you need to make contact with the court's compliance officer here in the courthouse to make arrangements to discharge your fine, court cost, and reimbursement fees. Your failure to make payments or pay that off will result in the court issuing a warrant for your arrest. Do you understand that? Do you understand that?
Yes, Your Honor.
Okay. All right, Mr. Jackson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step to your left with the bailiff to be fingerprinted.
Mr. Jackson, come over here. Mr. Weiner.
Mr. Weiner, is this Christian Pritchett?
Yes, Your Honor, it is.
All right, and I believe, are we set today for a hearing on the motion to adjudicate?
We are, as well as a motion to reduce bail. We have come to an agreement on the motion to reduce bail. I've got a signed agreed order that reduces the bail so long as the judge signs off on it from $150,000 to $75,000. And I will e-file that as soon as I get back to my office.
Tell you what, Mr. Weiner, I've got a copy of it here. If you have no objection, I'll just fill this out and it'll save you some time and it'll get it through the system a little bit quicker.
That'd be wonderful, Judge. I appreciate it.
Your agreement is $75,000?
Yes, Your Honor. And then as far as the actual motion, the state, realistically, the allegations are a new offense, which the state does not have that case yet, and some technicals that are typically filed if somebody hasn't had time to complete them. And so what I'd ask is that we reset this case to the 15th and see if we're able to come to a resolution before then, Judge.
Any objection from the state?
No, Your Honor.
All right, court will set Mr. Pritchett for hearing on this motion to adjudicate on December 15th at 9 a.m. I'm sorry, at 1:30. 1:30 if he's in jail, 9 a.m. if he's in bail. So, Mr. Pritchett, if you make bail on this reduced bail amount, then you're due in court at 9 a.m. that morning. If you're still incarcerated, then the court will come to you. You understand?
Yes, Your Honor.
All right, Mr. Weiner, if you will give him that notice of appearance, have him signed, then he can be excused.
And that's all I have, Judge. May I be excused?
Yes, thank you, Mr. Weiner.
Good seeing you again.
Mr. Merleader, are you ready?
Yes, Your Honor.
Okay, yeah. Just so you know, you can step up anytime, and if I see you there, I'll know you're ready. And who do you have? Is this Mr. Rodriguez?
That's correct, Your Honor.
All right. Court calls CR 19273 and FC 2042, State versus Anthony Lee Rodriguez. My docket indicates we're set for pre-trial on the FC 20 case and a hearing on the motion to revoke on the CR 19 case.
Your Honor, we have reached a plea agreement with the state on all of his currently pending cases.
Need to be on YouTube. Judge, are you ready for us to read the terms?
Just one moment. I need to, since this is a motion to revoke or adjudicate, I need to pull up his motion so I can admonish him. All right, Ms. Heisel, I'm ready.
All right, Your Honor, in cause number CR 19273, upon a plea of true to the state's motion to revoke, we recommend the defendant's community supervision be revoked and punishment assessed at 3 years confinement in TDCJ with the balance of financial obligations due. State is also going to 1245, the pending FC 20-42, which is an evading arrest with previous conviction charge, Your Honor. Mr. Rodriguez is going to have a balance of $2,000 in fines, $388 in court costs, and we are going to credit him 144 days jailed credit towards his sentence, Your Honor.
You said 144?
Yes.
All right, Mr. Rodriguez, if you will, raise your right hand. I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, Mr. Rodriguez, let me. All right, Mr. Rodriguez, here's that the state has filed a motion to revoke your community supervision on August 12th of this year. And in this motion, I see here that you appeared before the court on November 19th of 2019. The court reviewed the evidence and convicted you of the felony offense of evading arrest or detention with a vehicle. Court assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division with a $2,000 fine. However, on that date, the court also suspended the imposition of that sentence and placed you on community supervision for a period of 10 years. It was during that period of your during the period of your supervision that the state has filed its motion to revoke and has alleged in a single count of the various ways that you violated. At this time, Mr. Rodriguez, do you waive the formal reading of the state's motion to revoke your community supervision?
Yes, sir.
All right. And Mr. Merleader, do you believe your client to be competent today?
Yes, Your Honor.
You've explained to him his legal and constitutional rights?
Yes, I did, Your Honor.
All right. Mr. Rodriguez, as to count 1, as contained in this document, how do you plead to that count? Is that count true or not true?
I plead true.
Okay, and Mr. Rodriguez, are you telling me that that count is true because, in fact, it is true and for no other reason?
Yes, sir.
And no one's threatened you or forced you or pressured you to plead true to that count. Is that right?
Yes, sir.
All right. The court will accept Mr. Rodriguez's plea of true to the state's motion to revoke. And Mr. Merleader, is there any objection to the admission of the defendant's waiver of rights and plea of true?
No, Your Honor.
That's admitted into evidence. Court takes judicial notice of Mr. Rodriguez's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close.
Anything further from the defense?
Judge, I think there's also an outstanding CR-14 case. I believe the state plans on terminating the probation for that. But other than that, Your Honor, we close.
Your Honor, Mr. Cox is nodding his head in the affirmative that he plans to take care of that.
Okay, so that is that going to be a termination with?
It'll just be an order to withdraw and terminate community supervision, Your Honor.
Is that going to show successful completion or unsuccessful?
Unsuccessful, Your Honor.
Ms. Burns, is that going to cause any problems with your reporting?
No, sir.
So it's going to show that he unsuccessfully completed it. Is it already a conviction?
Yeah.
I believe so.
Okay. Okay, so that's not part of the agreement today. Is that correct, Mr. Merleader? That's just something that you're putting on the record that the state's agreeing to, but it's not part of this plea.
We don't have paperwork for it right now.
Yeah, we don't have the paperwork for it, Your Honor, but they're going to carry through with that.
Okay. All right, then, based on the evidence before the court, Mr. Rodriguez, the court will find that you have violated the terms and conditions of your community supervision. The court finds your plea of true to be true and accepts it. The court, based on that plea of true, hereby revokes your community supervision and assesses your punishment in accordance with the plea agreement and recommendation of the state at 3 years confinement in the Texas Department of Criminal Justice. The court orders you to pay the balance of your financial obligations, including the $2,000 fine, $388 court costs. The court issues you 144 days credit for the time that you spent in jail on this cause, and the court will dismiss under Section 1245, cause number FC 20-00042, the evading arrest or detention with a previous conviction. Mr. Rodriguez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you step to your left with the bailiff and be fingerprinted.
Thank you. Thank you, Your Honor.
Good luck to you. All right, court call CR 18231, State versus Georgie Marie Walker.
Your Honor, we're set today for, announcement on her MTA. Ms. Walker has been charged for, under the MTA, for her abandoning and endangering child criminal negligence, state jail offense. In addition to that, Your Honor, she has an outstanding unindicted aggravated assault with a deadly weapon case. The state has offered us a plea for both of those cases today, 20 months state jail with 1245 the aggravated assault. We'd like to have more time to review that offer, Your Honor. This is the first setting that the court has had since she's come back into the state's custody. I'm not sure if the state objects to that.
Any position, state?
We don't object, Your Honor.
Thank you, Ms. Curry. All right, then, Mr. Merleader, the court will set Ms. Walker then on December 15th. Do you have any scheduling issues that date?
No, Your Honor.
That'll be at 1:30. Is that all you have, Mr. Murray Leader?
Judge, we have one final case. May I speak with the prosecutors on that?
Yes, I can recall you. Is that on Mr. Lennox?
That's correct, Your Honor.
Yes, take your time.
Mr. Lennox? Yeah.
I was just informed we do have 4 more on the way, so we probably hold them there. Do you want to do this? Yeah.
You shouldn't take more than 10 minutes.
Okay.
I don't think so. Mr. Lennox, come on. We're putting on the record that we're rejecting the state's offer and requesting the case to be put on docket call. And after that is when the case will be put on jury trial. Right now, the only offer that we have is 25 years. The state might have a different offer than that. They will send over here. There it is.
All right, court calls cause number CR 20133, State versus Micah Lennox. And we're set for pre-trial today, is that correct?
Yes, Your Honor. Shroff Murley there for the defendant, Mr. Michael Lennox. Your Honor, we don't have any contested pretrial issues. I have filed a few defense pretrial motions, including the standard motion to limine, request for witnesses and 404B evidence, as well as request for state's witnesses' criminal histories if the state has it. At this moment, Your Honor, we have reached no plea agreement with the state. The state's last plea offer was 25 years TDCJ on the reduced aggravated sexual assault of a child. Mr. Lennox has expressed to me that he does not wish to take that offer. At this time, we would announce that we have no offer and no contested pretrial issues, Your Honor.
That's great.
Thank you, Your Honor. And I just want, because of the nature of the offense here, Judge, and the penalty range that is attached to that offense, I want our record to be abundantly clear. Mr. Lennox is charged with continuous sexual abuse of a child, which is a punishment range minimum of 25 years that, as the court knows, must be served day for day. In other words, if we go to trial and the jury finds that the state has proved this case, one of our pieces of evidence, of course, will be Mr. Lennox's confession to the offense. If the jury agrees with us that he did in fact commit this offense, the jury will have no choice but to impose a sentence of 25-year minimum day for day that must be served by this defendant. We have made the defendant a plea offer in this case that would not require day-for-day sentencing, would make him eligible for parole. At this time, on the record, I'm going to make our final plea offer to him, and that is for 20 years on an aggravated sexual assault of a child, that an offense where he is eligible for parole after serving half of that. So in other words, by law, he would be eligible for parole after 10 years if he accepted that, versus a trial where if a jury believes his confession, he faces a minimum of 25 years day for day. I just want our record to reflect that very, very clearly, Your Honor.
Thank you, Ms. Curry. Mr. Murray Leader, what I think would be best at this time is, since there are no contested pretrial motions from the defense, is that allow the court to set this for a docket call on December 15th And that way you and your client can fully consider Ms. Curry's revised offer and the legal ramifications regarding accepting it or not accepting it. And then we can come back on December 15th and Mr. Lennox will have had more opportunity to make an informed decision.
That's just the date, saying we acknowledge that date. Thank you, Your Honor. I'll speak with my client about that final offer, and we'll be ready to make a decision on December 15th about whether he requests to go to trial or agrees to accept the state's offer.
Thank you, Mr. Meyer Leader. All right, Mr. Lennox, we'll see you back on December 15th.
Yes, sir. And Judge, that's all I have. May I be excused?
Yes, sir, you may. Thank you. Very good to see you.
Thank you, Your Honor.
Your Honor, it's just taking another moment or two for the next group of defendants to come up.
Okay, that's fine. Just step up when you're ready.
Yes, sir. Thank you.
All right, Mr. Sanders.
Yes, Your Honor.
And who do we have here with us? This is Mr. Brown, right?
Yes, that's correct.
All right. Court calls 2020-73 and CR 20-150 State versus Judson Taylor Brown. Set for pre-trial on both. Is that correct?
Yes, Your Honor, that is correct. Judge, on the felony case, the CR 20-00150, we're asking for it to go ahead and be, we don't have any pretrial issues. We asked for it to be set on docket call. And then on the misdemeanor case, we have a plea agreement on that case. We've executed all the plea papers and are prepared to enter that plea on the misdemeanor case.
Okay. Go ahead and give me the terms on the misdemeanor plea.
Judge, this is a Class B theft of service, and upon a plea of guilty, the state is going to agree to 162 days confinement in Van Zandt County Jail with credit given for 62 days credit time served, a $500 fine, $270 court costs, and $365 in reimbursement fees.
This is a Class B theft. Is that, what's the range on that? 750 to 750?
It's 100 to 750, Your Honor.
100 to 750. I guess this is a little unorthodox. Pleading, Mr. Brown's going to plead out to an offense, and while he's potentially waiting for trial on a felony, he understands that this could be used against him as punishment if he goes to trial. Correct?
That is correct, Your Honor.
Okay, and he's willing to accept that risk.
Yes, Your Honor.
Okay. All right, Mr. Brown, if you will, raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. You are Judson Taylor Brown, correct?
Yes, sir.
Mr. Brown, you are a United States citizen and you do read, write, speak English, correct?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case here and have all of your legal questions answered?
Yes, sir, I do.
Is there anything about the plea agreement that you have signed that you do not understand?
No, sir.
Mr. Brown, you are charged by information with the Class B misdemeanor offense of theft of property, $100 to $750. That carries a range of punishment of a maximum confinement of 180 days in the Van Zandt County Jail and a fine not to exceed $2,000. Do you understand that full range of punishment?
Yes, sir, I do.
And you've heard Ms. Heisel read the plea agreement. Is that your understanding of the plea agreement in this case?
Yes, sir.
Yours as well, Mr. Sanders?
Yes, Your Honor, it is.
All right, Mr. Brown, how do you plead then to the Class B misdemeanor offense of theft of property?
Guilty, sir.
And Mr. Brown, are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
And no one's threatened you, forced you, or pressured you to make you feel like you had to plead guilty. Is that right?
Sure.
All right, court accepts the defendant's plea of guilt to that offense. And Mr. Sanders, any objection to States 1?
No objection.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. Brown's judicial confession. Anything further from the state?
Yes, Your Honor. It appears that Mr. Brown was never arrested on this particular charge, so I do have a TRN processing order here with the plea paperwork. Mr. Brown is going to remain in custody on his other charges, so we should be able to get that executed by the jail.
Okay. Anything further from the defense?
No, Your Honor.
All right, Ms. Heisel, if you'll go ahead and just give me a brief summation of the theft allegation.
Yes, Your Honor. Mr. Brown went to the home store and entered into a rental agreement with them for a computer. Mr. Brown then failed to make rental payments on that computer and failed to return that computer back to the home store within the prescribed time period.
Any objection, Mr. Sanders?
No objection.
All right, then based on the evidence, Mr. Brown, the court will find that there is sufficient evidence to convict you of this offense, and the court does convict you of Class B misdemeanor theft. The court assesses your punishment in accordance with the plea agreement at 162 days in the Van Zandt County Jail. The court gives you credit for 162 days of time served. The court assesses a $500 fine, $270 court cost, and $365 in reimbursement fees. Mr. Brown, upon being released from the Van Zandt County Jail, or if you can make arrangements before then to start discharging what you owe the county, you should contact the Van Zandt County Court Compliance Officer. With regards to CR 2150, the court will reset Mr. Brown for a docket call on December 15th. And Mr. Brown, I'm going to have you step to your left to be fingerprinted with the bailiff, and then we'll see you back on December 15th.
Yes, sir. Thank you.
Is that all you have, Mr. Sanders?
Yes, sir. Yeah, it is.
Yes. Noel, do you have any inmates ready?
Yes, I do. Mr. Gutierrez is ready.
Step on up, Mr. Gutierrez. This is CR 2050, State versus Jesus Humberto Gutierrez. And we're set for arraignment today, I believe, on aggravated assault. Daily book.
That's correct, Judge. I've reviewed the facts in the indictment with Mr. Gutierrez. His name is spelled correct, and for the purposes of arraignment, we'd enter a plea of not guilty.
All right, court enters Mr. Gutierrez's plea of not guilty into the record, and we will set pre-trial on this case. Mr. Noel, did I set you earlier on another date this morning? I think I set you on December 10.
That's correct, Judge.
All right, we'll go ahead and we'll set Mr. Gutierrez on that same day for pre-trial. Does that give you enough time? That's a little less than 30 days. Do you feel like that's sufficient time?
I did pick up some video today, so I have some discovery. We'll move forward to get the rest of it.
Okay. All right, then Mr. Gutierrez, we'll see you back on December 10th. If you make bail in your case, you're ordered to be back at 9 a.m. in the courtroom on that date. If you do not make bail, then the court will come to you at 1:30.
Sir.
All right.
Judge, you also have here now Mr. Pfeiffer, Dakota Pfeiffer.
All right, CR 20266. Mr. Pfeiffer will step up. We were set for pretrial.
We are, Judge. I believe I have almost everything that I need. I need to probably ask the state about one other thing. If we could set this for pretrial, probably 12:10 would also be good.
What is it that you believe you're lacking?
There may be some issues of whether there's another incident or incidents where this particular officer believed he was trying to stop Mr. Pfeiffer another time. There's some other report to that effect.
Any objection from the state?
Judge, this is the first I've heard of this request.
Do y'all want to visit for a moment, and we'll call Mr. Pfeiffer up here in a second?
I think that's a good idea, yes, sir.
Let's do that. Just have a seat, Mr. Pfeiffer, and then we'll revisit in just a moment.
The only other one I have, and I think it's set for arraignment also, is Dawn Davis. I could not locate her. Oh, well, no, I've located her.
Discovery.
Davis.
All right, this is cause number CR 20112, State versus Dawn Lee Davis. Go ahead, Mr. Noel.
We're aware of the charges against her. Her name is spelled correctly in the indictment, and for the purposes of arraignment, we enter a plea of not guilty. I may already have all the discovery. If we could just set one more pre-trial, then I'll have the opportunity to sit down with her and discuss how we need to handle the case.
All right, the court will enter Ms. Davis's plea of not guilty into the record. We will set this matter for pretrial on December 10th. Miss Davis, if you make bail, it will be at 9 a.m. on that date. If you do not make bail, then it will be at 1:30, and the court will come to you. Okay?
Yes, sir. Yes, sir.
And Miss Davis, you're free to go.
And Your Honor, we are in the middle of another switch of defendants. So if you'll give us a few minutes, we'll get somebody up here shortly.
Yes, ma'am, we'll do.
Yeah, I got you. Yeah, I got you. Can I? Wait, oh, okay. Using the other 149 cases I have, eventually they all be taken care of. Oh, great, yeah, all right.
All right, any further development on Mr. Pfeiffer?
Judge, there may or may not be something else. The state, I think, will attempt to talk to the officer, and I think it's important to look at the video that does exist. And I actually don't think it was Mr. Heisel or Miss Heisel or Mr. Cox that made the offer on the case. I don't remember. Mr. Woodwhite. I think it was Mr. Woodwhite, and I haven't had a chance to talk to him about the case at all.
Okay, so you're asking for another pretrial?
I am, and we may be able to resolve it on that date, but I don't know that yet.
All right, court will reset Mr. Mr. Pfeiffer for another pretrial on December 10th at 1:30 in jail, 9 o'clock.
If that's all I have, may I be excused?
Yes, thank you, Mr. Knoll.
Thank you.
Mr. Stevens?
Yes, ma'am.
Probably step on that.
Mr. Stevens, are you ready on Anna Cervantes?
I am, Your Honor.
Step on up, Ms. Cervantes. PR 16-354 and 355. We're here today for hearings on motions to adjudicate.
Yes, ma'am.
Your Honor, we have an agreement as to cause number, well, we have an agreement as to both of them, but on cause number CR 16-354, which is the prohibited substance in a correctional facility, upon a plea of true, the state's going to recommend that the defendant's guilt be adjudicated and community supervision be revoked and punishment be assessed at 3 years TDCJ and a balance of financial obligations due, which include $1,500 in fine, $71.52 in court costs, no restitution or reimbursement, and 127 days jail credit towards her sentence.
And is she going to play true to all counts?
I believe so, yes.
Yes, sir, that's correct.
And is that a dismissal or a 1245 of CR 16-355?
Your Honor, we have a motion to withdraw the state's motion to adjudicate. We are going to ask that that community supervision just be terminated and allowed to expire.
Okay. Anything else?
No, Your Honor, that's it.
I don't know if I understood that.
Okay. Do you now? Judge, may I step aside with her for just a second?
Yes, please. we ready?
I think we're ready to proceed, Your Honor. She had a couple of questions and I cleared up for her.
Okay. Ms. Cervantes, if you'll raise your right hand, I'm going to place you under oath. Ms. Cervantes, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, make sure you speak up loudly and clearly so my court reporter can take you down, okay?
Yes, sir.
All right, you put your hand in. All right, you are Anna, is it Delia Cervantes?
Yes, sir.
All right, Ms. Cervantes, you last appeared before the court on February 9th of 2017, and you pled guilty to the third-degree felony offense of prohibited substance or item in a correctional facility. At the hearing, the court found that the evidence substantiated your guilt. However, the court deferred a finding of guilt in your case and placed you on community supervision for a period of 5 years. The court also assessed a $1,500 fine. It was during your term of community supervision that the state filed its motion to adjudicate or revoke. They filed that on February 11th of 2020, and they alleged in 4 separate counts various ways that you violated the terms and conditions of your community supervision. Mr. Stevens, does your client waive the formal reading of the state's motion at this time?
Yes, sir, we do.
And is it your client's intention to be true to all counts?
It is, that is correct, Your Honor. She plead true to each account.
All right, Ms. Cervantes, I'm going to ask you at this time, are you pleased with Mr. Stevens' representation of you?
Yes, sir.
Is there anything about the plea agreement that you signed that you do not understand?
No.
Are you sure?
Yes.
Okay. And your signature throughout the documents, that is your true and correct signature, is that right?
Yes, sir.
You signed where your signature appears, that means that you understand everything that you read and signed. Is that correct?
I didn't know what it said.
Could you repeat that, Your Honor?
Yes. Where you sign, your signature appears throughout the paperwork. Does your signature being in that paperwork mean that you understood everything that you read?
Oh, yes. Uh-huh.
Okay. So let me ask you at this time, as to count 1, count 2, count 3, and count 4, how would you plead to those counts? Are those counts true or not true?
True.
And are you pleading true to each count? To all counts? Are all those counts true?
Yes.
Yes.
And Ms. Cervantes, are you telling me that all those counts are true because, in fact, they are true and for no other reason? Is that correct?
Yes.
And has anyone threatened you, forced you, or pressured you to plead true to any of those counts that are not true?
No.
All right, the court will accept Ms. Cervantes' plea of true to each count as alleged. Mr. Stevens, is there any objection to the admission of the defendant's waiver of rights and plea of true in evidence?
No, Your Honor. No objection.
Defendant's waiver and plea of true is admitted into evidence, and the court takes judicial notice of Ms. Cervantes' judicial confession. Is there anything further from the state?
No, Your Honor, we would rest and close.
From the defense?
No, Your Honor. Rest and close.
All right, Ms. Cervantes, based on your plea of true, the court will find that you have violated the terms and conditions of your community supervision. The court finds those counts to be true. The court adjudicates your guilt, convicts you this day of prohibited substance or items in a correctional facility. The court assesses your punishment, revokes your community supervision, and assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice. The court orders you to pay the balance of your financial obligations, including your fine and court costs. The court issues you 127 days jail credit for the time that you have spent in jail on this cause. With regard to CR 16355, the court accepts the state's motion to withdraw and terminate community supervision and will sign the order affecting the same. Ms. Cervantes, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. I'm going to have you step to your left to be fingerprinted by the bailiff. Good luck to you. Is that all you have, Mr. Stevens?
I have one more, Your Honor. I have a bond reduction on a Jacqueline Smith.
All right, Ms. Smith, if you'll make your way to the podium. This is number WR20-63, State of Texas versus Jacqueline Smith. And Miss, are you going to call Miss Smith as a witness?
Yes, Your Honor, for the limited purpose of this bail hearing.
Miss Smith, if you will, raise your right hand so I can place you on oath. Ma'am, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Make sure that you speak up loudly and clearly so my court reporter can take down everything that you and I say. Also, do not talk over Mr. Stevens. Allow him to complete his question before you give an answer. He's going to extend the same courtesy to you, okay?
Yes, sir.
All right, go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
Miss Jacqueline Money Smith,
Ms. Smith, how long have you been in jail?
possibly 30, 31 days.
Okay. And you're being held on a $10,000 bail for the possession of a controlled substance, which would be a state jail felony. Is that correct?
Yes, sir.
Obviously, you don't have the $10,000 or any means to raise that money, do you?
No, sir.
Do you have any property that you could sell upon or mortgage to help raise the money for that?
No, sir.
Okay. And if the judge were to reduce the bond, or you're going to ask even for a PR bond, if he were to grant that, if you were to get out, can you go to work?
Yes, sir.
Where would you go to work?
I worked at First Monday for a gentleman, another lady. I built a tent at First Monday and also have a job offering at the nursery.
Okay.
I forgot the name of the nursery.
Okay. And would you live with your family?
Yes, my daughter.
Okay. And where is that located?
It's off of Highway 19, going towards Emory.
Okay. Would you have transportation to and from the courthouse?
Yes, sir. I have a vehicle.
Okay. And you have a medical condition that you're needing to seek treatment on. Is that correct?
Yes.
And I believe it's your left jaw you said is broken?
Yes, it's shattered.
Okay. And prior to being incarcerated on this charge, you had, I don't know if you had surgery set up, but you had an appointment to go see medical people, correct?
Yes, sir.
Okay. Are you asking the judge to grant you a personal recognizance bond?
Yes, sir.
Have you ever failed to show up in court when you've been ordered to?
No, sir.
Okay.
Yes, yes, sir.
When was that?
Back in 2008, I was arrested. Between 2008 and 2010, I didn't show up for court. They put me back in for 7 months.
Okay. Did you learn your lesson by not showing up in court?
Yes, sir. I was worried where it was at Monday.
Okay. Now look, if the judge doesn't grant a PR bond, are you asking him to reduce it to around $2,500?
As long as he can get it.
Okay. And if it's like $1,500 to $2,500, is that an amount that you believe that your family would be able to help raise to get you out of here?
Yeah, possibly if they would. I don't know. I work for myself. I don't depend on my family.
Okay. I'll pass the witness, Your Honor.
Your Honor.
Any questions from the state?
No, Your Honor.
No questions at all?
No, Your Honor, we can just reserve our argument.
Okay.
That's
Go
all I have, Your Honor.
Go ahead, Mr. Stevens. Any argument, Mr. Stevens?
Oh, yes, Your Honor. We're just asking for a personal recognizance bond. And if the court does not deem that's appropriate, we're asking you to reduce it to $1,500, Judge.
All right, thank you, Mr. Stevens. Go ahead, State.
In Your Honor, the state would oppose any reduction or PR bond at this time. We don't believe that Ms. Smith is eligible under the law. If Ms. Smith reaches that 90-day mark and we are unable to proceed at that point, we would potentially reconsider our position. Additionally, if Mr. Stevens were able to present us medical records for Ms. Smith on her medical condition, we would potentially change our position. But as for now, we would ask, Judge, that you remain her bond at $10,000. Find that to be fair and reasonable.
Thank you, Ms. Heisel. Any rebuttal, Mr. Stevens, at all?
No, Your Honor.
All right, then. I just based on the testimony that Ms. Smith gave, there's some indication of previous criminal history. I'm not real clear on what that may be, but the court will find that at this time, $10,000 is not unreasonable or excessive. Court will deny the request for a personal cognizance bond or a bail reduction at this time. However, in 60 days or so, if Ms. Smith either submits medical documentation to the court would reconsider its position, or if Ms. Smith is not indicted timely under the law, then the court will grant a personal recognizance bond at that time. So the court will reconsider under those two circumstances. But as for now, based on the evidence, the court will deny the request for bail reduction.
Thank you, Your Honor. Might be excused.
Yes.
Thank you.
Mr. Turner, why don't you come on up, sir?
Yeah, they've already gone.
Actually, Mr. Stevens, give us just a moment, we'll step outside and we'll visit out there. Oh.
Your Honor, are you ready?
Yes, is this Mr. Turner?
It is, Your Honor. State has a motion to dismiss that I've signed, and I'm going to give the deputy McLeish to bring over to the courthouse for the court signature. Mr. Turner has been sentenced to, I think, around 7 years federal time. So the state's going to dismiss our case on Mr. Turner.
Okay. All right, then the court will grant the state's motion to dismiss and sign the order when it's presented. And good luck to you, Mr. Turner.
All right, thank you.
Are y'all done with Mr. Turner?
Yes.
You know, on Miss Davis, I forgot, she's got that habeas profile issue, doesn't she?
Yes, sir.
We did, it's her lawyer, that's Mr. Knoll. Guess we'll wait and talk with her on 12/10.
Okay.
I forgot to mention that today.
All right, very good. Is there anything else we can do for you here, Your Honor?
I don't think so. Is there anything I can do?
I'm sorry.
Anything I can do for the jail?
I'm sorry, Judge.
I'll see if I can do it. Is there anything that I can do for the jail?
Oh, thank you. I think they're good. As a matter of fact, I'm so confident they're good that they left the room. So
Ask not what the jail can do for you, but what you can do for the jail. That's what I'm trying to say.
yes, sir. I'll extend that offer to them, but I think we're good over here. Thank you, sir.
All right, thanks. See you in a bit. Yes, ma'am.